Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Acting U.S. Attorney Matt Whitaker is enjoying the shortest of honeymoons. In office for just over a week, he now faces a court challenge by the state of Maryland challenging his validity to be acting attorney general. And high-ranking Democrats are also calling for his recusal from oversight of special counsel Robert Mueller's investigation. House Minority Leader Nancy Pelosi, Senate Judiciary Committee Ranking Member Dianne Feinstein, and others have sent a letter to Assistant U.S. Attorney General in charge of ethics at the Department of Justice, urging him to advise Whitaker to recuse himself from supervision of the Mueller probe. The Justice Department has stated that Whitaker will consult with senior ethics officials about his oversight responsibilities in any matter that may warrant recusal. In their letter, Democrats claim Whitaker should not be overseeing the Mueller investigation because he has a history of hostile statements toward the investigation, has prejudged it, and has served as chairman of Sam Clovis' 2014 campaign for Iowa State Treasurer and stayed in close contact with Clovis since then. Yet making unfriendly or antagonistic statements or prejudging the investigation do not meet the legal test for recusal. But what about Whitaker's personal and political relationships? Well, according to DOJ regs, Whitaker may not participate in a criminal investigation if he has a personal or political relationship with any person substantially involved in the conduct that is being investigated, or if he knows that person has a specific and substantial interest that would be directly affected by the outcome of the investigation. Former Attorney General Jeff Sessions, who served as a top foreign policy advisor to Trump's campaign, cited these grounds in support of his recusal. Whitaker, not having served on the Trump campaign, must dig deeper in his analysis. The regs define a personal relationship as close and substantial, the kind that would normally induce partiality. Whether a friendship rises to that level is a determination Whitaker must make based upon his own subjective opinion. And what about a political relationship? That might exist if Whitaker has a close identification with Clovis, the former Iowa Treasurer candidate, that arose from Whitaker's service to him as a principal advisor on his campaign. So it's possible Whitaker could have a personal or political relationship with Clovis, but that's not the end of the analysis. Clovis must have been substantially involved in the conduct being investigated or have a specific and substantial interest that will be directly affected. Democrats point out that Clovis served as the national co-chairman of the Trump campaign, and in that capacity, they argue, supervised George Papadopoulos, the Trump foreign policy advisor who sought to set up a meeting between Vladimir Putin and Donald Trump during the 2016 campaign, and who has pleaded guilty to making false statements to the FBI regarding his contacts with agents of the Russian government. Also, Clovis has been interviewed by Mueller's team and has testified before the grand jury and House and Senate committees investigating this matter. Now, what exactly is the conduct being investigated? Mueller was appointed to investigate any links and or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, and any matters that arose or may arise directly from the investigation. Now, because the letter appointing Mueller gave such a broad mandate on his authority, it's possible that Clovis could meet the substantial involvement or interest test. But even if Whitaker makes each of these determinations that point toward recusal, that's still not enough. Whitaker can supervise the Mueller investigation if he determines that, notwithstanding his relationship with Clovis, and assuming Clovis has a substantial involvement or interest in the investigation, he believes he'll be able to conduct himself in a fully impartial and professional manner, and that his participation would not create an appearance of a conflict of interest likely to affect the public perception of the integrity of the investigation or prosecution. And there's the rub. Although he may reasonably believe he'll be a fair and impartial supervisor, Democrats and the media are ginning up the appearance of conflict to create in the public's mind the perception that Whitaker will harm the integrity of the investigation. In short, they're trying to answer that question for him by creating that very public perception. But at the end of the day, it's Whitaker's decision, not theirs. If Whitaker believes he can be fair and impartial, he should resist the massive pressure placed upon him by Democrats to recuse himself. It being so obvious there's no collusion, Whitaker may be the best person for the job. If he has the personal strength to resist the gale force winds calling for his recusal, he may also have the strength to shut down the investigation that a year and a half later, and $17 million in taxpayer dollars later, and despite filing over 100 criminal counts against 32 people and 3 companies, has not produced one shred of evidence of collusion. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law of recusal concerning members of the Department of Justice. That's about all the time we have today. Thanks for listening, and enjoy your lunch.